Young, and I'm Monica Young. I'm the host of the Global Real Estate Investor Club and broker of Just Global Inc. Today, we have the honor of inviting Ms. Michelle Bau to speak about the latest on trust and asset protection. I have personally known Michelle and her family for many years, and Michelle is very hardworking. And not only that is she licensed to practice law in California, but she was also permitted to practice law in Canada and England. She worked with many local and international clients. She can speak Cantonese, Mandarin, and English. So we've been going back and forth about this presentation, and she has many new ideas that we never heard about before. So without further ado, may we now invite Michelle to start. Michelle, you have the floor.
Good morning, Monica. Good morning, everybody. It is a pleasure and a privilege to be with you today. I have known Monica for 10 plus years, and I know how much her clients trust her. She's grown the assets for her, and she's protected the assets. And the purpose of my talk today is to discuss how we take those hard-earned assets and how we transfer them to the people we love and how we protect them. So thank you for having me. Thank you for sharing the time this morning on a Saturday to be together. Okay, so I have a lot of slides to share with you. I also have a lot of pictures, so hopefully I can keep everybody engaged and paying attention, because we've mixed not just the content, but pictures as well. And we'll have a lot to cover. Hopefully you have your coffee or your tea, and we should begin. So, okay, so before we, there's always a disclaimer. Anytime you talk to a lawyer, the information I'm sharing today is for informational purposes. It is not to be relied as a legal advice, as an attorney-client privilege, and it is meant to be general. And if you have something that you want to see an attorney for, you definitely need to make an appointment and to get the legal advice. But we're going to be covering a lot of general concepts today for educational purposes. Now, a few things about myself. Why are we talking about trust, and a little bit about my background, my professional background? I specialize in trust in LLCs and real estate, and it's been 23 years since I've been practicing as a lawyer. That's a long time. It felt like yesterday. I don't know where the time went. I have an office over in Los Altos, and that is where I am this morning. So it really helps to have a physical office. I think that these days, it's just so many people, they say who they are, and then they make you think they're one thing, but unless you physically see them, like Monica in person, unless you see me in an office in person, it's hard to know who to trust. And so I have a physical office in Los Altos where I meet my clients. I have advised over the years many local and international clients in California, whether they have a house here, whether they have assets, children studying here, or they have just a connection to California, but they are either still working or living in Asia, in Canada, or in different countries. As Monica mentioned, I am qualified to practice law not only in California, but also in Canada, in Ontario, as well as in England and Wales. And so what that allows me to do is be able to have a network of professionals, other lawyers that I can easily call up. And we have a trusted relationship, so that it really serves the client best, because having a lawyer being able to contact the local counsel and having a good working relationship makes things go much faster. And also not just internationally, but also domestically. I have lawyers that I work with across the US in different states. I do speak, in addition to English, I speak Cantonese and Mandarin Chinese. And as I mentioned, I have people that I email, call, and am in communication with around the world. And so that takes years to build that trust. And that is a benefit that I bring to my clients. I work closely with other commercial and residential real estate brokers like Monica, and as well as wealth managers, hedge fund advisors. And when they know that their clients need to see a lawyer, I am definitely, ready to help. And finally, I am an active community member and a volunteer. I have young children, and so I do try to also make sure that I spend time with them and try to be visible in the community as well. So that's a little bit about myself. Okay, so first of all, thank you for coming and congratulations. And you might be wondering, what am I congratulating you for? Well, getting into Zoom is always a little bit uncertain, right? We're not sure if it's going to work for us, if we have the right link. So I think it's wonderful that we've all made it to the meeting. But the congratulations is also for just taking the time to spend, your Saturday morning together, talking about estate planning, and how many chances are we really going to do that, right? To spend a Saturday morning talking about something that a lot of times we just want to save for another day. So congratulations for taking the first step to getting closer to getting this estate plan and taking care of your loved ones. And here's a picture. This is the reason why I am congratulating everybody for attending, because this is a topic that most people do not want to think about, but it is definitely something we do for the people we love. Oftentimes, if we're gone, some clients say, why should I care? Why should I care if I'm gone already? Well, it's definitely for the people that are still behind that we are talking about these issues, and to make things as smooth and seamless for them as possible. So that's not us. That's not a picture of us lying on the couch. And then the other question, people take time and just don't get their estate plan done.
Michelle?
Yes?
Can you move the slide down that we can see your screen?
Move the slide down.
Yeah, because we do not see the latest slide that you talk about.
Okay.
Yeah, I know that you are now on the 5th slide, but then I think the audience is still seeing the first slide.
Oh, let me see. Okay. Oh, okay. Maybe we should just have, should we pull up the?
Oh, now it's moving. It's moving. Now it's okay.
Now it's moving?
Yeah, we just
Okay.
saw the slide that with the person on the couch, and then you have to move. Yeah, move to that slide.
Okay, okay, I'm glad now. Okay, so maybe even the computer needs to wake up on a Saturday morning. Let's see, so we got this one. Now we're here. Okay, well, let me know, Monica, if something comes up again. So you can see this who can help screen?
Yes.
Okay, all right.
Yeah.
So this one is, sometimes I ask my clients, how did you find me? And they said, well, it was really hard finding you, because they're not sure. They've been, finally, when they feel like getting off the couch and doing something about it, then they don't know who they want to talk to about it. And so that can also be a reason for the delay. The delay is just not knowing who is there to help and understand and really put themselves in the client's shoes and try to find a solution. So that's sometimes a reason for the delay. Now, we are going to cover a lot of topics, but one of the topics that is on everybody's minds is inflation. And so inflation has gone up so much, right? It's gone from, it's somewhere hovering between 8 to 9%. And the studies show that 58% of Americans are living paycheck to paycheck. And that is, that number is just sounds really high. And what is even more surprising is that people with incomes over 250,000, 30% of them are also living paycheck to paycheck. There's been a lot of, I'm sure we all have heard of people who have been unemployed because companies are not doing well. And so it is a bad situation, but it just means that we just have to plan and adjust and adapt. And so inflation, as everybody knows, it's gone up 8 to 9% in the last couple of months. Food is up, the cost of food, gas is up tremendously. It's come down a little bit, but definitely up from a year ago. Okay. So about estate taxes and how, well, before we leave inflation, why is inflation related to estate planning? And the answer is it's twofold. In the time that we are alive, it affects estate planning because when we spend more than we need to, when we used to spend, now that things cost more, we have less money. The $1 million that we thought we had in savings will now last a lot less. So if the $1 million is now worth less because it can buy less goods and services. So that's on the front end. In the back end, when we give our loved ones that $1 million, that $1 million also doesn't go as far anymore, right? It used to cost $1 million to buy something. Now it'll cost maybe $1.2 million. So it's affecting us in the front end and the back end. And that is why inflation is also impacting estate planning. So with estate taxes, there's so many taxes that we have to, sort of separate and talk about separately, but estate tax is separate from capital gains tax, and that's different from income tax. That's different from property tax, right? So there's lots of different taxes, but for estate taxes, that is a tax that the government charges 40% on. But there's an exemption that US residents have. That's about $12 million. And if you're a married couple, you have $24 million, which sounds like a lot, right? So anything above 24 million, the government will charge 40% for every dollar above 24 million. Now, the problem is that there's going to be some uncertainty. The law that allows the exemption to be up to $12 million is going to expire in 2026, which is in about 4 years. So in 4 years, that number could drastically, now anything can happen between that time, right? A new law comes in from Biden or whoever the president will be at that time. But that $12 million is going to suddenly drop down to 6 million. And according to some proposed laws from Biden, that $6 million will be further reduced to $3.5 million, the exemption. Now, suddenly, that exemption, which is $24 million for married couples, they said, well, how many people, have that? Not that many people have over 24 million. But when we bring it down to 3.5 million and then double it for married couples at 7 million, then suddenly it's going to affect a lot more people in the Bay Area, right? That's a number that a lot of people might hit. So a lot more people for sure than 24 million. And so if you look at the slide in the table, it shows that suddenly, where under the current law, there would be no taxes due in 4 years' time, based on what's available in the law, it could suddenly become a $3.8 million tax liability. And that is significant. That is why it is very important to talk to somebody, an accountant, a lawyer, somebody about how to plan for these changes in the law. The next slide we're going to talk about is probate fees. A lot of times my clients think that sometimes the estate taxes, probate is the same thing, but it's two different things. Probate is something that we in California can avoid. And so probate in different jurisdictions, in different countries, in different states, even if you have a friend in New York, if they passed away, chances are they still have to go through probate. But in California, the law is designed so that if you have a well-drafted and maintained living trust, you can avoid probate. So you can actually have something like a get out of jail free card where you can just avoid this whole process. And you do want to avoid this process because currently there are 2 judges for over 2 million residents in Santa Clara County. And so that's actually an improvement because that's been a recent change. It used to be 1 judge for over 2 million residents. And so if you think about how insufficient that is, imagine if there were only two doctors to serve 2 million people in Santa Clara County. That would be very scary, right? Because not everybody will die at the same time and need to go to probate. But to know that there's only 2 people who are going to serve up to 2 million, it doesn't sound adequate. Even if we had 2 doctors serving 2 million residents, right? Not everybody will get sick and die at the same time, but to think that there's only 2 people who will have to go through things if they are not organized, if the documents are not organized, only 2 people will review these cases, seems like it's going to take a long, long time. And so fortunately, we can avoid this process if things are done properly and well maintained. And the other thing about probate, so first of all, there's not enough judges to take care of the residents. So it's just not staffed well enough. So it's going to be years of delays. The next thing is it's also going to be extremely expensive. If you look at the probate code, the fees charged on probate, that's based on statute. It's not something that can be negotiated with the lawyer. The lawyer just charges us because it's in the law. So it's going to be based on a sliding scale. It's based on a percentage of how much a person owns on a gross value. So if you say, oh, my house is worth $1 million, but I owe, $900,000, the government doesn't care. They only look at the $1 million, right? Same as if when you sell a house, you're not going to sell it at the net value of after your debt. You're going to sell it at the full value, and then you deal with all the payments after the fact. But that 4% on the first 100,000, 3% on the next 100. So most people would fall in the 2% category. So imagine if 2% of your gross assets will be tied up in probate. So not only is it expensive, it is also going to take a long time to resolve. And in that period, all your assets will be frozen. That is very scary, because if you've got children, if you've got loved ones who need that money to function, all of that money will be locked up in court and frozen, because it can't disappear until that matter is heard in court. That money has to stay in the accounts, and the only way to keep it in the accounts is to freeze all the accounts. So definitely something to avoid is probate, and it can be avoided. So inheritance planning, do I need a trust? This is something that a lot of people ask me if they need a trust. And the answer is yes. If you've got people that you love, if you've got over $100,000, if you've got people you love, if you've got real estate, you do want to have a trust, because that is a way to, we'll use a car analogy. You'll understand it through my slides later. That is the way you're going to pass the asset to your loved ones, avoiding the court process. So if you've got people you love, if you say, I don't really care about my money, I don't have anyone that I want to make their life easier, then maybe you don't need a trust. If you don't have money, okay, then you don't need a trust. But if you've got people you care about, you want to make sure it gets to them without being tied up, then the living trust is the solution, and also the solution to avoid probate. And so we're going to talk about all of these things in very close detail. But one of the also very important things about a living trust is that it's a private document. Now, a lot of clients are surprised that when they hear the will, they thought, well, all I need is a will. But the will have to be a public document that has to be filed in court. So that's where we need to make a huge distinction between the will and the trust. The will, even if you have a will, and even if you saw a lawyer to prepare the will, that still needs to go through the court system. And because it goes into the court system, it is a public document that everybody can see. And by having a trust, it's kept private. So nobody gets to look inside that trust. And so you guard your privacy. So what is a living trust? A living trust does 3 major things. The first is that it distributes your assets, the money that you worked your whole lifetime to save and grow. You get to give it to the people that you want to give it to, and keep the wrong people out. So people like overpaying the government is not something that anyone wants to do, right? Giving it to the wrong people, whether it's creditors, whether it's in a divorce, a spouse that shouldn't have access to that money. This is the way to do it. Putting it in a trust to keep the in-laws, spouses, creditors, lawsuits, anybody out and not touching that money. The other thing a living trust does is that it manages the money. And that's something that a will cannot do. So it talks about how to actually keep the money and preserve it. And so the protection part is the protection against taxes, creditors, divorces, lawsuits. That is what the living trust does. Now, unfortunately, not all living trusts are the same. So I have examples of trusts that are 3 pages long, 5 pages long, 10 pages long. The clients come to me, they want me to take a look at their trust. And so I'm happy to do that. And everybody that's attending the seminar will also be able to make a free consultation with me. But when I see the trust, they're definitely not the same. A well-prepared trust and a 3-page trust is night and day. But unfortunately, there are people out there that are preparing trusts for $1,000, and that is where that saying, you get what you pay, unfortunately comes true. So just because a person thinks they have a trust, you still should get it looked at and make sure that it's doing what it's supposed to do. Now, the analogy I mentioned about the cars, right? This is just to keep things a little bit lighter hearted. Now, are all cars built the same? Is the only difference between cars the price? Are they built the same? I don't know how many people recognize that car on the right. It's called a Yugo. It was made in Yugoslavia. It was sold to the US in 1986. And then 7 years later, it was banned from the government. It could not be sold anymore because it has been deemed the worst car in history. And so these are both cars. However, the car on the right is so poorly made. It is so dangerous to drive. And so which car would you want to put yourself and your loved ones in? And the problem with the car on the right is that the problem, when do you know what you've got, is when it's too late, right? So you see that Yugo, that's the name of the car from Yugoslavia. How do you know you've got a bad car? Is when you go, right? Hopefully people are paying attention and recognize that that attempt to make a joke, when you know you've got a bad car is when you go, which is also the name of that car. So unfortunately, we don't want to find out the hard way that things were not done properly. And so it's important to get things done. You only have one chance to get this right? You care about these people that you're leaving behind. You don't want to leave it to chance and then find out that the trust that you thought was safe is actually not going to do anything. Now, here's a picture. It's about, will your trust work properly when you're sick and disabled? We don't want to see ourselves sitting, getting old and getting sick. But unfortunately, it is a reality that happens. And so these days, the current life expectancy is going up, which is a great thing, right? Medical technology, modern medicine is all working well. We're all living longer. However, so in terms of life expectancy, it's about 79 years old now. California, which is good news, we're in the second place for the states with the longest lifetimes at about 80, almost 81 years. So that's a good thing that we're living longer. However, there are problems that arise when we get older, and dementia is one of the major causes of disability among people worldwide. I'm sure we all know somebody that we love who has or has had dementia. And so it's estimated in the studies that there's a new case of Alzheimer's every 65 seconds, which is alarming. And so when people are diagnosed with Alzheimer's, if they are about, and these are just averages, but to give an idea, If they find out at 65, they have about 8 years to live. If they find out at 90, they probably have about 3.5 years to live. The point is that even when the person starts to lose their mental ability to function, they're still alive. And so the problem becomes people are living longer, but they're not able to take care of things anymore. And that is why there needs to be certain documents in place before they lose their mental function that allows the people they trust to step in and take care of things when they should be able to just slow down, right? They cannot be working till they're 90 years old. So we're going to talk about what happens when people get sick, right? Because people are living longer, but they are getting sick when they get older. It's not 100% health as we keep getting older. And so the question is, who will make the decisions on your behalf? Who will pay the bills? If we are the only person who are paying the bills, what happens if we start missing the payments? We could lose our home. The government could start knocking on the door. Things could turn completely upside down. And so even these are hard questions. I have clients who come to me, they're in their late 80s and they're still not ready to make that decision, but they have to, because there really isn't a whole lot more time where they still have their mental ability to make these choices. It's a hard choice, but it's incredibly important, because we all know in that last 2 years how many people we loved. You know, either we lost them to COVID or we lost them due to an illness that was related to COVID. And so these people just left, you know, very quickly, right? They didn't even have a chance to even say goodbye. So worldwide, there were 600 million people who got COVID and 6 million deaths recorded. Now, of course, the actual numbers are higher. We all have heard in the news of countries that just, they're not even counting. They're just throwing the bodies. They're either burning it, throwing it, and just getting rid of the problem. So the point is that people get sick. They don't always have time when they are sick to make these decisions. So it's important to take care of these documents regardless of age. Now, the other thing is about, will the living trust? So some people have a living trust, but will it really avoid probate, right? That's kind of like having a car, but not putting any gas in the tank. So it doesn't matter if you have the best car out there. If there's no gas, the car will not work. So sometimes the clients will come in and they say, I already have a trust. But when I do some searching in the public records of where things are, they either refinanced the real estate and forgot to put it back in the trust, or the lawyer that they first saw was such a bad lawyer that they created this 3-page trust but didn't put anything in there. So even though it's called a trust, this paperwork, nothing is in the trust. And so that is very dangerous, because it gives a false sense of security to the people who thought that they were going to be protected. And so that's why the question is, okay, you need a trust. But if you have a trust, is it going to take care of you? And that's where you're really testing the quality of the document. So all the assets, the big assets, should be transferred into the trust in order to avoid probate. Remember that slide that talked about how there were only 2 judges to decide how assets go for 2 million residents in Santa Clara County. And so that is just shocking, right? We just definitely do not want to fall in that system. And so the way to do it is by having a properly drafted and maintained trust. So the question is, do those internet or do the do-it-yourself or bargain attorneys take care of this? No. Chances are you call them back up, they're out of business by then, or they'll just forget that they even met you. So there's no relationship with those, right? You just plug in, answer a few questions online, you get something that comes out of the printer. It's not going to, chances are it's not going to do what you need it to do. It's kind of like that car called the Yugo. And will your living trust keep up with the estate tax law changes, right? Remember that slide that in a few years, the tax laws are going to change, right? The $12 million is going to expire in 4 years. It's going to go down to 6 million according to the current law. But according to the proposals by Biden, it's going to go down even further from 6 to 3.5 million. And so the exemption that is now 12 million will very likely be a lot lower. And so that is where you want to have a lawyer who's going to keep up with those tax law changes and look out for your family, understands your family, understands your specific situation and how to plan for that properly. And chances are, when you go to those internet and do it yourself bargain attorneys, that they're not going to keep up with the estate tax law changes. They're probably not even going to be in business when you need to go see them again. The other question to ask also is, will your living trust protect you and your loved ones from losing their inheritance to unwanted third parties or the government? Now, those are just funny pictures to show the point. There are so many scams out there right now, and they are not going to look like that person on the left in the screen, right? The person with the hat, with the gold chain. They are incredibly sophisticated scams that are out there, right? I'm sure we all know people we love. Off the top of my head, I've heard of my clients describing their situations who have lost in total easily over $1 million. And so everybody feels ashamed about falling for these scams. And so it is a real problem, but it's out there. There's people who are spending all their energy, those bad people, spending all their energy on how to steal money from people with money. And when they hear that somebody just got an inheritance, right? If you hear friends, or suppose you have children, right? You give them money, $1 million after you leave. Their friends hear about them. Suddenly they're going to pitch to them. I got a great business opportunity. Let's get into business. Let's do this together. Next thing you know, the money is gone. And I've had clients who come to me where they said that they trusted their business partner. And when they came and checked their bank account, everything had disappeared. So that is not just horror stories. That is actually real stories. And the people who are going to take the money won't look obvious at all. And of course, the other picture on the right is the government. The government wants the money without proper planning. And how are you going to protect the people you love? Outright distributions of a large amount of money is not a good idea, right? As we mentioned, there's the scams that are out there right now are incredibly sophisticated. Billions of dollars are being lost. Studies show $30 billion are lost by phone scams, 55 billion in identity fraud, 14 billion in crypto scams. Some of them are called pig slaughtering, Ponzi schemes, the Theranos, remember Elizabeth Holmes. And the response from the FBI, if you file a report, it's just an online report. You never hear back, right? That is how, I've helped my clients. I've tried to do something for them. It falls into the abyss. You try to tell the government, you try to ask for help from the FBI. There's too many problems out there. Too many people have lost their money. They can't respond in time. So it is a real problem out there. Every week, I feel like I am being solicited by somebody who wants to steal money away. And so it's just out there right now, and it's a real problem. And so fortunately, by knowing Monica, somebody you trust, by knowing me, if you feel like something isn't right, you need to call somebody you trust and make sure that it sounds legitimate. Have them step in, and chances are that will go away when you have somebody else step in on your behalf. If you give money to the people that are too young to manage it, not a good idea, very dangerous, right? Anybody who is older, who is lonely, depressed, they get these calls from people who sound very sincere. All of them are just they're just trying to steal money away. And same with addiction issues. A lot of people right now are facing addiction and they can't handle the money. So that's why it's important to just put it into a trust so that you're protecting your loved ones. And it's something that I would do for my own kids as well. The next thing is that even if you think that my kids are never going to fall for a scam, they'll never have friends that are going to tell them to go into a bad investment. The problem is that the divorce rate is so high in this country these days that it is very possible for the spouse to just get divorced, and then half the money is gone in that way. Or forcing, even if they're still together, they're going to force that money that was protected, because inheritance is actually separate property. It's a protected money. That money you get from your parents should never have to be split into half if you divorce. But if your spouse convinces you to use that money on something together, to buy together, whether it's a house, a vacation home, a car, suddenly it loses its protected status. So it's very important that even if you feel your kids will never make the wrong decision, if they share it with the spouse, suddenly that money is at risk for losing 50%. And of course, we talked about just having bad luck, going into debt. Nobody ever thinks that they will ever go into debt, ever owe money, ever have a business go wrong, ever be sued. I mean, every day when we drive a car, we run the risk of, God forbid, an accident. And if an accident happens, suddenly everything is at risk that you've worked so hard at. And of course, there's lawsuits out there. Some of it have no merit, and that will threaten to take the money if the money is in your name. If you keep it in a trust and it's never fully, it's for the use, for your benefit, you get to control it. But as long as it's not in your name, that money is protected. And of course, there's always the possibility of even another tax coming up when the government really needs money. Right now, California doesn't have an estate tax, but of course, some states already have the estate tax. So there's a possibility of a second tax. The solution to all of this is that there's a trust that can be designed where it's called a personal asset trust. The beneficiary, which is your children, can actually manage it. They can be the trustee of that money, that $1 million you leave to them. They can control it. They can have access to it. But the trust owns the money. So even though they have control over it, that money is not under their name. And because it's not under their name, that money is protected. And so the goal is to get asset protection and also to minimize income taxes, because if the money is not in their name and that money generates, it grows, they don't have to pay income taxes. Now, here's a case study. I don't know how many of us can relate to families like this, but basically, in this example, a family has 3 children. There's Bob Jr., who is, just done everything right? Everybody is so proud of him. And he is in a great profession. He has lots of money, makes great decisions. But unfortunately, he has she has a high maintenance spouse, a difficult spouse, and does certain things that can be dangerous on the side, right? Investing in something that is just got high risk and high reward. And so even Bob Jr. can lose his or her money. Then there's Jane. Jane is the person who is very responsible, but maybe doesn't have the financial experience, probably, having some issues, sacrificed, her productive years raising a family. And so who knows, maybe there's just going to be problems ahead for that marriage, right? And so if that happens, that money is at risk that the parents would be leaving to her. And then there's Jim, who hasn't found himself yet and is relying on government benefits and has people that are looking for him for money. And so it's not safe to give these particular people, even the high achieving one, it's a little dangerous to put it into a spouse because of who that person interacts with, whether it's their spouse or the friends or the business partners that they spend their time with. Now, there's an option. If you create a personal asset trust where that money goes to. So instead of going directly, suppose you leave $1 million for these 3 kids. Instead of going directly into the hands of these kids, you put a layer in between them and the money. Then it's suddenly every one of them, no matter whether they are responsible or haven't found themselves yet, suddenly they are better protected. They're better protected against creditors. against divorces, against businesses that go wrong, and things in case they get into an accident. Those judgments and those lawsuits won't affect the money that you have worked so hard and saved up for their benefit. So that is a very good solution. There's also something else that is less common, but definitely out there as a benefit that the government provides. And it's called an IRA inheritance trust. And that means that the money, so the most people's biggest asset is the house, right? Is the house that Monica, she's excellent and she gets you the house. That's the biggest prize. But after that, it's usually people's retirement accounts. And so that is another area where asset protection needs to take place. But having a standalone, having a trust, so in addition to the living trust, there's also an IRA trust. And the reason to do that is to protect against creditors, right? All the people that are out there trying to steal the money from your children. We get asset protection with this IRA trust, and you get to also reduce the income. So right now, estate tax has become so high currently, right, at $24 million for married couples, that income tax is the new estate tax. Everybody's trying to figure out how to reduce their income tax. And a way to reduce income tax is also by putting the IRA into a separate standalone trust. Now, when people have an IRA, they need to put a beneficiary for the IRA. So here in this chart, we're going to look at 3 different ways of holding that money, to send that money either to an individual directly to your children and to your spouse. The problem is that it doesn't accomplish any income tax reduction, and there's no asset protection between divorces and creditors, lawsuits, none of that. There's no protection at all. So that is the worst way to give your IRA money away to the people that you love directly. The second way to do it is by putting the money into the living trust that you may already have. The problem is that maybe there can be some income tax advantages, maybe some asset protection, but the best way to do it is by the standalone separate IRA inheritance trust. That way the money is safeguarded. It will have a trustee. It could be your own kids who are the trustee, but it is the trust who owns the money, and it can accomplish the income tax benefits and also guard against direct ownership of the money. And by avoiding the direct ownership, you are actually protecting the asset. So the IRA inheritance trust, there's no effect while you're living. It's same, but it's just changing the form so that for the beneficiary, you would say that it's the name of your IRA inheritance trust. And there's a lot of potential benefit protecting that money, right? Making sure that $1 million you save for them is going to still be $1 million and more. And that's the purpose of that trust. And so it's not for everybody, but for where the assets are over, if you have husband and wife over $250,000, it makes sense to have that trust for the people that you leave behind. So the point is that there's a lot more to estate planning than just filling in blanks, of just answering some questions on your own on LegalZoom. It really requires a lot of professional counseling. And so as an attorney, it's very much an advisor in law and just telling you how to take care of this money, how to keep it so that you can actually pass it down to the people that you care so much about. So it's not just a simple, do-it-yourself type of trust. Now, when you meet an attorney, you're going to talk about a lot of things. You're going to talk about who is going to be the best person to be your successor trustee. We talk about taxes. So for instance, there's a whole concept about step up in cost basis, and that is talking about avoiding capital gains tax related to real estate. So when real estate is held, if you hold it under community property, you get a full step up when one person passes away. If you hold it in joint tenancy, you get a half step up. So a lot of times, unfortunately, when people buy real estate, They're at the title company at 8 o'clock in the morning. They've already, all the money is already in the title company, and they're waiting to get their key. Then they're asked to fill out a form. How do you want to hold title to this new piece of real estate that costs so much money? And so if you ask the escrow officer, they said, you have to ask an attorney. They can't give you that advice. That's too late to call an attorney at 8 o'clock in the morning on the day of closing, right? But if you actually had a lawyer that you trust, that you can call up and have them advise you, then you would understand the whole the whole step up in cost basis. You would understand why community property is better than joint tenancy from a tax point of view. The lawyer can also answer questions on Proposition 19. There's definitely pros and cons about it. That was something that passed a long time ago, about a year and a half ago. But the problem is that it's not like a wonderful, people are worried that they missed the chance to transfer the real estate to their loved ones. It's actually, if you keep, it's always one thing versus another. You gain one, you lose the other. So if you want to gain on keeping property taxes low, you miss out on the full step up in capital gains later. So now that the opportunity has passed for Proposition 19, it's okay, because by transferring ownership upon death, the person would get a full step up and eliminate all capital gains from being taxed. So that's a whole different separate conversation, but having an advisor, having a lawyer that you actually can work with can explain all of that, instead of reading all these things in the news and not feeling like any of it makes sense or that it's all inconsistent information. Now, oftentimes you might want to ask, do I want to have one successor trustee or do I want to have co-trustees? Right? That's a common question. There's pros and cons, and that's something that should be discussed. And then talking about how each of the beneficiaries, the inheritance, right? There's a lot of conflict that arises. When you have one child, less conflict. When you have 2 or 3 children, how much do you leave to each kid? How were they able to manage money? And did one child spend a lot of money at school? And then that way you should probably leave more money for the other people who use less money by going through advanced degrees right at school. If you had to pay for one child's education, do they get less after you die? And what about the child who needs more money because they just have a job that pays less than his brother and sisters or her brothers and sisters? Should that child get more money? How do we plan for that? Right? Those are all things that require a lot of discussion, one-on-one discussion with a lawyer that you trust. And it's impossible to get that with somebody that you're just going to hire for $1,000 or somebody that you're just going to talk to over online or do it yourself. Those are not the type of things that will give you the proper attention that your estate needs, and to maximize the benefits and to protect the money, because chances are if something goes wrong, that person is already gone, right? But if you filled something on LegalZoom, chances are if something goes wrong, you can't sue them because you've already disclaimed saying that you understood that when you paid the $1,000, they are not responsible for what they've produced for you. But if you go to a lawyer, they are absolutely responsible for what they produced. And so I'm going to go through a couple of slides here that show why it's very important that every single family situation, which is different, requires different issues and different things that need to be talked about. For married couples with young kids, who is going to take care of those kids? Are under 18? Who is going to take care of the kids, right? Do you have a separate person who's going to take care of the kids versus who's going to manage their money? It doesn't need to be the same person. It's the person who you think is going to do the best job caring for your kids and caring for that kid's money. It could be 2 different people. And when do they get the money, right? That is a very important discussion that you can't just answer on your own without a proper discussion. And that is where having a professional that you trust is going to make a difference. For couples, clients that I see with grandchildren already, how are they going to pass the money from their children, if their children don't need the money, straight to the grandchildren? Because when money changes hands from parent to child to grandchild, there is at each point a tax that takes place. But there's also a generation skipping transfer tax And so that can only be taken care of if you see a lawyer that can handle that type of discussion. So that's GST planning, generation skipping tax planning, and that is going to be an irrevocable trust after the parents die, and it also has asset protection language in there to prevent against spouses who want to divorce and take half the money, or just judgments and lawsuits that are going to, so it actually keeps the money. These GST trusts are going to keep the money in the hands of the people that you love and want to make sure that they're taken care of. And that's not the kind of trust that you can do on your own or with people that are just trying to be here today and gone tomorrow. Now, for blended families, that is the new normal these days, right? Children, people divorce, people remarry, and as a result, there's a lot of complicated issues that come with children from the first marriage and children of the current marriage, or just children from prior marriages all living together in one household, right? We all know people who have just dealt with this, right? Even like Sheryl Sandberg, the former COO of Meta, she's now remarried, and and even Jennifer Lopez, Ben Affleck, all these people have blended families. It's very common. And so, but they come with a whole host of special issues that need to be talked to with a lawyer, because without the proper planning, there is going to be a lot of fighting after the people have passed. And that is the kind of, that is where the value of having a trusted professional comes in. Now, for single people, they might say, I don't really need a trust, right? I don't, it should be very simple. It's never that simple. For every situation, there is, even for singles, what happens? Who are you going to trust to take care of you, right? Because if you're single, you got to think about, you got to ask friends and family members to take care of you when you can't manage the money on your own. So that is a lot harder of a decision, right? Who are you going to have pay the bills so that you can stay in your own house? And so when you're not there, who is going to have those assets, right? And so that a lot of times for my clients who are single, unmarried, without children, that trust is not simple at all. It's very complicated. And so it's not to be underestimated how complicated trusts can get if we do it properly. And so other issues that come up for non-US citizens have a possibility of forming a QDOT, a qualified domestic trust. That is a special trust that you cannot get with those Zooms or those attorneys that are just, doing it for $1,000, because that's very dangerous. If you have a non-citizen spouse, and if a proper trust is not put in place, and the citizen spouse passes first, leaving the non-citizen spouse to inherit the assets, the exemption is going to be ridiculously low, that almost immediately the IRS is going to be knocking on the door to get the money. And so that can be avoided if you have the proper trust in place. Now, by coming to see me, I also give my clients a successor trustee manual, because chances are the person that you pick has never done this job before, right? There's going to be checklists, there's going to be how to avoid personal liability as the successor trustee, and that is going to be a handbook so that we can avoid IRS audits. So that is a successor trustee manual to avoid, to at least know what to do when you are the person who is being named as the successor trustee, and how to avoid personal liability. Now, by coming to me, I do offer a free service package, which means that you're welcome to call me if you have questions. So if you are at the escrow company at 8 o'clock in the morning closing on a transaction, and you could call me, and if I see you ringing, I will pick up the phone and answer that question of whether you want to hold your real estate in joint tenancy or community property, or if you're about to just, if your kids get married, any sort of questions that come up. I'm always happy to take your call and hear how you're doing, even after you've signed. There's also going to be newsletters to keep you informed of what I'm up to, what I'm working on, new issues, changes in the law, and there's going to be a free checkup meeting every 3 years. So every 3 years, remember we talked about having a proper trust. You need to keep the tank full, right, of gas. And so you can't have a trust and then the tank is empty. So we need to meet every 3 years to make sure if you've got assets after we signed, that those assets are not going to go to probate. So I would encourage my clients to come see me after 3 years. Life changes. Maybe the people you wanted to leave the money to, maybe those have changed, right? And so, or maybe the amounts that you want to leave them has changed. And so, or maybe you've got additional real estate that you sold or bought. And so that's a good chance to come and reconnect with me. Now, hopefully you've learned and heard about a lot of stuff. It's probably a lot that just that I've put out there. But from here, we can talk about the right plan. And so, okay, there's 3 types of plans that I offer. There's the basic, there's the asset protection, and then there's the IRA trust, because those are slightly different. And so instead of everybody's going to have a copy of these slides that attends this presentation. You can look over it carefully, but generally the basic plan says that if you were not alive, the money goes outright to the following beneficiaries. So it's an outright distribution. That's called the basic plan. And that's the most straightforward. But if you want asset protection, because of all the stuff that we talked about, why there's tons of people that are just, if they know that you are sitting on money as a beneficiary, they are going to be knocking on your door, talking about how to get rich quick, right? That is what we're trying to protect against. And that is the asset protection trust. And then finally, there's also the IRA trust. And that is another trust that is offered. And we can always talk about that when we meet in person. And for everybody's time, I know everybody's time is money. And so what I can do is for Monica's, clients and friends, I would be willing to knock off $500. If you're able to review those slides, think about it, and see if you want to meet in about a month, anytime before the month. These are the prices that is discounted. So the basic depends on if you're a single person or a married person. The gold package is for the trust with asset protection. And then the platinum is where you would get a separate trust, a third trust, which is the IRA trust plus the asset protection trust. And then the free service package, where every 3 years we would get together and we would review and make sure everything is funded so that there is gas in the tank of the car. And if you already have a living trust, I'm also willing to sit down and review it and give you an opinion of what it says, because a lot of times people have trust, they're not sure what's under the hood, right? Nobody has checked the engine. Nobody has done anything. The client knows they have a trust, but if I ask them, what does it say? Chances are it's not very clear, right? So that's why having it reviewed, making sure for something this important that you know crystal clear what it says. And I'm happy to show you exactly word for word in your trust where it says what it says, right? So I just want to treat the person as if I was on the other side of the desk as well. So the $500 discount is if you schedule a free appointment and you come in for a consultation in a month. And so that is for the time that you have spent on a Saturday morning listening to me talk about estate planning. And hopefully that'll get us off the couch. Remember that slide initially about sitting on the couch? Hopefully this will get some of us off the couch. And so the question is, which one would you rather your loved ones have? Would you rather them having a car that actually you know what you're getting? If you paid for this, chances are it's a very solid car. Or if you get the Yugo, on the other hand, it is very dangerous. It's been deemed the worst car in history. And so you definitely want to, as a consumer, be able to know what is under the hood. What is this car made out of? So when you look at the trust, you want to know what is in this trust. And so, You want definitely the experience, the expertise definitely counts. And so the greatest benefit, I thought I'd end with a happy slide, is just a peace of mind. Once you've gotten a great trust, you know that the people who you love are actually going to be protected, and so that they can move on and continue to have the money, right? You want that money to stay in their hands that you have worked so hard for. You've all been extremely patient, and I hope there are questions. I'm happy to answer questions at this point. Thank you for listening.
Thank you, Michelle. That's very, very informative. And so I have posted to everyone, if they have any question, they can enter into the chat box. I'm sure that many of them would have. Personally, I do have some questions. Michelle has been helping our family to create our living trust a couple years ago. So I believe maybe, I thought like we might have a basic trust. So what is the difference between like having an extra step for the asset protection? Like what do we have to do to get that extra asset protection?
It's extra language in their same revocable trust. So the trust that you have right now, it would stay the same name. However, there would be additional language which says that in case there's a threatened lawsuit, in case of anything where there needs to be greater separation, then instead of the successor trustee, say your children are going to be the successor trustee. This asset protection trust is after the parents have already passed away. So instead of going outright to the kids, it's going to stay in the trust. And the reason it's going to stay in the trust is for the asset protection. And so there's 3 levels of trustee rules. There's the successor trustee, which are likely the children. So they are in control. They get to decide when they want to pay themselves the money without having the money in their name, right? That's the first tier of protection. So there's a separation because that money never reached into their name. So there's that protection. But when things look like, for instance, when the marriage doesn't look good and it looks like there could be a divorce or looks like there's some trouble, right? You get into a new business, you don't want to lose the house with the business or your parents' money with the business. Then you go into a special trustee. Then there's a second role. So you go from successor trustee to a higher level. That's called a special trustee. And if that still doesn't solve the problem, there's a third tier, and that's called the trust protector. And usually the trust protector is either an attorney that steps in, or it's going to be a private fiduciary. So certain companies like Wells Fargo, the private client divisions, those types of companies will step in to protect the assets. But that's in the most extreme, the top tier. But the trust will have all of this built in. So it's just features that can be activated when there's reason to feel that something is not going right.
Got it. So I think a lot of us have made like revocable living trust, but I have noticed some very wealthy people, they set up like irrevocable trusts so that like they can distribute the money to the kids without having, them kind of like spending everything at one time. So is the irrevocable trust is almost like a personal asset trust? What is the difference?
It's a little different because by having an irrevocable trust, that means that the trustee and the beneficiary cannot be the same people. So when we talked about that personal asset trust, the child can still be initially the trustee. And only when things don't look right, then they find the special trustee and then they go to the trust protector. But when things are fine, they are in control of the money, even though it becomes irrevocable, because when parents have passed away, that revocable trust becomes irrevocable. But if we start off with an irrevocable trust right away, what happens is that that trustee is not the same person as the beneficiary, because otherwise that just cannot work. Then that means that that child has to ask somebody else, whether it's an uncle for the money or the bank. And so when there is that level of uncertainty, whether or not that person will pay the money, that always causes a little bit of tension and conflict.
Got it. Yeah. So I think, of course, like we are new to all this legal concept. I guess, if you're going to provide a 30-minute free consultation for my clients and also who have registered for the event, I'm sure that they would have like a more personal questions and that they can address, with you when you meet and, have those answers. Also follow up in terms of like the trust. So for the people who are, like, say, young and they don't have a lot of assets, do you think it would also be helpful to set up like either a will or trust, at least, to set up health directives? How should we, like have the young people get their protection as well?
Absolutely. I would encourage young people to have a trust as well, because when they get married, then the money they had before, this trust that they created before they got married, is protected. It becomes, either they can call it a prenup trust or they can call it a separate property trust, whatever. If the future spouse doesn't like to hear the name prenup trust, then call it a separate property trust, or just call it the name of the person. And by the date of it, because it happened before marriage, it will be separate property. So it makes a lot of sense to have a trust even before marriage, because it makes it very clear that that money was not to be commingled.
That's a very good point. Now I have a couple questions from the attendees. The first one is will putting a transfer on debt on the house be voided, the probation? I personally, transfer on debt, which is TOD, on the house be voided, the probation. So
yeah, that is not something that is common. Putting the transfer on death on a real estate deed. It is possible, but it is certainly not common.
That's more technical than I've come across.
Yeah, it is not common practice to do that.
To talk to Michelle personally. And this question is from Kelly. How to avoid children becoming trust child? I don't know, like what. Yeah, Kelly.
How to protect the children from being a successor?
How to avoid the children become trust child. So I thought, like, when children under 18, they need to have like guardian or advisor, if they were put as a trust trustee to inherit. So, her question is how to avoid children becoming trust child.
I guess I think I know. Yes, they don't want them to be a trust fund baby, right? Yeah. So the way is to keep it away from just to have an education trust, right? In the trust that I prepare, we can definitely set the terms that this money has to be for either education, for either a standard of living that is the same as when the parents were alive. So it cannot be, unless they were used to having, private jets when the parents were alive. When the parents have passed, they're not allowed to have private jets, right? So it is definitely possible to make sure that the trust, the money after the parents passed away, is not going to be wasted, and to think that the money can be used for frivolous purposes. Yeah, there's definitely ways to protect against the beneficiary from thinking they are a trust fund baby.
Got it. This question is from Maria. She said, what if she has sold an expensive house and need to change the trust immediately? You mentioned that you're going to include, say, a free checkup every 3 years, but what if she needs to reach out to you? Would that be a charge?
That's okay. I mean, I'm here for phone calls too, right? Definitely. If there's something urgent and there's something about selling an expensive house and not knowing what to do with the money or whether to roll it into a 1031, definitely. That's something that's why having a good relationship with an attorney is important. That things need to be decided before the wrong decision is made. So for sure, definitely with my clients, they call me up before they make a decision, because it's much harder. Once you've gifted something to a child, you cannot have it gifted back, especially if that child has been married. You're not going to get the agreement of that other spouse to say, give the money back now. That was a mistake.
Yes, totally agree. Can you explain a bit more about the dynasty trust? Would that be kind of too long, or?
That's okay.
We heard about the term.
Yeah, the dynasty trust is essentially this. It's just the same thing as the generation skipping trust. That's called the GST. And that just means that in California, we have 92 years to pass the generation from the parent to the grandchild. And so we can skip a generation. It can't go on forever, but it can last beyond the generation. It can skip a generation. So the parent can put money into a trust. That's the dynasty trust. The parents, if they pass away, the money doesn't get immediately distributed to the child. It will pass tax-free into the hands of the grandchildren in a properly drafted trust. That way, the less hands that touch the money, then the IRS cannot tax it.
Got it.
But there is a limit.
Yeah.
There is a limit on how far that can last.
Yeah, I would encourage Kelly. Yeah, Kelly can speak directly to Michelle about your needs and any other follow-up questions, please. I got another message about, like, say, explain how special need trust can be set up, how to execute it when needed. If beneficiaries have been receiving government subsidies, how to avoid losing the subsidy.
Mm-hmm.
I don't know, like, would that be like disability or whatnot? Any audit by government agency on how the beneficiary get the money and what is the cost to set it up on top of the regular trust?
Mm-hmm. That is a subspecialty in terms of a kind of trust. It's not the average trust, but the trust can be worded so that the trustee only releases the money to the special needs child when the government benefit is not enough. So the way to continue with government benefit means that the money cannot be owned by the child. So the way the trust, it's similar to the PAT trust that we were talking, right? The personal asset trust. It's very important that the money cannot be in the name of that child, the special needs child. Because if it is in the name of the special needs child, it will disqualify them from the government benefit. So it cannot go into their hands, but it needs to be, there needs to be a trustee who is able to supplement and is able to make sure that that child is okay if there's not enough from government benefit. So there has to be a separation, right? There's got to be some level of separation between the child and the trustee so that the government cannot say it's the same person.
Got it. Yes. I often have clients who close their properties in trust, living trust, and they thought they have some form of asset protection. But at the same time, I have clients who actually been creating LLC to actually, kind of like having that particular property limited to that LLC. So I know you mentioned about asset protection trust and all this, but it's a different aspect. Can you explain having a trust? Would that be able to provide any kind of protection if my clients own that property and then it was, say, in litigation?
Yes, it's a very good question. And so when clients, when you have a regular, it's a living trust, it only becomes asset protection when the people who created the trust have passed away. So for that PAT trust, it becomes irrevocable when the parents pass away. When the parents are alive, there's no asset protection because the people who created it are still alive and they have control over the asset. I hope that makes sense, right? That when you do a living trust, and it's a revocable living trust, that has no asset protection. This asset protection happens when the parents have passed away, and then that money is going to go to the kids. And the question is, does it go outright to the kids' names, or should it be kept in the trust so that the kids can still manage their own money under the name of the trust? But when they are alive, so this LLC still has a purpose, right? I have clients who have put real estate in the LLCs. It's because the parents are alive and the parents want asset protection. So the LLC has a carrying cost. And so we have to look at the value of the real estate, how much can be purchased as umbrella insurance, and whether if there's tenants, whether there's the liability. Sometimes it makes sense to put one LLC for all real estate. Sometimes it makes sense to have a few LLCs. That's the kind of evaluation that you get from meeting a lawyer one-on-one to talk about the situation. And the lawyer should look out and not just say, I want, if the client says, I want 10 LLCs, I don't just go ahead and do 10. I think, is that really necessary? I look at the value of each real estate, the cost of carrying, of operating that LLC, of filing the different tax returns for each LLC. Does it make sense?
Yes, I totally agree. So like if the clients have a trust, a living trust, it can be the founding member of an LLC. They can own the LLC under a trust. Is that right?
Correct.
I see. But you would be able to provide consultation if, say, my clients need to set up LLC for the apartment building. You would be able to help them to do that as well.
Correct. Yes, I have formed LLCs for clients. I've had to dissolve them. I've had to, so there's all kinds of things. But definitely, I can help with the LLCs, the operating agreement that needs to be in place. And then actually integrating, right? The key part is integrating, because if you go to a different lawyer to do the LLC and it's not the same lawyer who did the trust, then the LLC is not funded into the trust. And so it becomes two different entities, right, that are not communicating to each other. The LLC has to know the trust exists, and the trust needs to know that the LLC exists.
Yeah, yes. So it's good. Yeah, it's a total solution. Great. I have a question now from John. He said, if he just need to specify who will pay the bill, who will find a maid, or who will find the doctors for him, and who will manage the finance, is a will sufficient?
No, it's not. The will is going to be a public document. That's first of all, and it doesn't go into the management. It just goes into the distribution. Remember in an earlier slide, we talked about how the trust actually accomplishes three things. In this slide, it says distribution, management, and protection. The will only talks about distribution. It will not talk about asset protection. It will not talk about management of your asset. And it's a public document, which is a big turnoff for most people, right? Nobody wants to have their personal finances litigated in court. And I should have mentioned this earlier, is that there are people who died without a will. And so so that whole slide about the procrastination is that, let's go back to that slide. A lot of people are procrastinating. We have names like Princess Diana died without a will. We have Abraham Lincoln, who was a lawyer himself and president of the United States. He died without a will. We have Stanley Ho at 98 years old who died without a will. It's shocking, right? He could have hired the best lawyer in the world, and he still didn't think he was going to die and leave a will. So he procrastinated. So if Stanley Ho can procrastinate, I think everybody in this world can procrastinate, but it's not a good idea, because it meant that the family were fighting bitterly. So that's why it's not too late. If you've already put it off, nobody wants to think about it. Nobody wants to talk about it, but it is. A lot of people put it off. But it's okay because, you know, it's just something that is unpleasant. And that's why I congratulated everybody for attending, because by spending a Saturday morning talking about this already is a big deal. So I think it's great that we're thinking about it.
Yeah. Well, let's address the last question, and that's from Bibi. And she asked whether you do litigation as well.
I don't do litigation, right? I forgot to also mention that I'm one of the good guys lawyers, right? There's lawyers have a bad reputation. There's the ones who sue, and so I don't do anything with the suing part. I do my documents as preemptively as possible. That means that it will avoid litigation. And so, but if it does go into litigation, that's a separate part. It's like going to a doctor. The doctor that you see will not be your surgeon, first of all. The surgeon is a different role. And so that is because that's just a different practice. So when you see a doctor, there's different practice areas. And so what I do is the planning, and I do it so that we avoid litigation.
Okay. Yeah, I got it. Sorry, I was thinking about the last one. So basically, let's answer this one as well. And Jessica asks, what happens to the living trust when one spouse passes away?
Yep, that's why that successor trustee manual, remember I mentioned that my clients get this? That successor trustee manual is very important, but it's part of the free service package. If you come in as a client, if somebody passes away, that is the time to call your lawyer and sit down with them. And chances are, if you called the bargain lawyer that you hired for $1,000, they are not going to answer the call. They're not going to be talking to you again, right? They just did it, collect your money, and disappeared overnight. So definitely need to sit down, need to talk about the title of the assets that were owned. Because if everything was put into that, if we said that car, if you had seen your lawyer every 3 years to make sure that the car you had, which is the trust, was constantly had a full tank of gas, everything is fine. But if you realize there were assets that were in the trust, or there were assets that were in the person who passed away's name, then there's a big problem, right? That means that the person who died has an account, has money that is now frozen. Because if, as a spouse, if you go to the bank or you go to the brokerage company and you say that I'm the spouse and I need to get this money out, they don't care. You can say I've been married to this person for 50 years. They don't care. There has to be a legal document. And so the only way to know how much legal help you need is how prepared you've been when both people were alive, and how that car is, whether it has a full tank of gas or it needs to actually needs a little bit more gas, right? If it's been maintained. And that's why sometimes there isn't a lot to do after one spouse passes, if everything's been titled properly. But if it hasn't been titled properly, then it may have to go to a short form probate. And that has happened where bank accounts have only, suppose the husband died and it was all, the husband died, the husband had a bunch of separate property accounts, it won't automatically go to the wife. It has to go through a short form probate in order to change the money into the wife's name. It's not as bad as the full-blown probate. So I don't want people to get super nervous, right? Remember, we talked about 2 probate judges for the entire county. You don't have to go stand at the back of the line for that. There's a short form. There's a short form, easier track. And that's for married couples when one person has died and the other person has assets that are still in that person's name. Then you don't have to go into the long line. You can go into a short line. But it's still better to avoid the whole line, right? Just stay out of court, period.
Yeah. Yeah, having planned in advance would be helpful.
Exactly.
So she also has to do everything in advance. And she also has a follow-up question about, like, how about the estate tax if only one spouse passes away? Is it due yet or no?
That's where the whole non-US citizen comes into play, right? So if one spouse passes away and they had a trust, then it depends on what the trust says, whether or not the surviving spouse is able to have full control or not, right? And that's where if you answered the questions on your own on LegalZoom, we don't know what the trust says afterward. That's dangerous because there are choices to make. When one spouse, suppose husband and wife, one person passes away, does the surviving spouse have full control over the assets, or do they have limited control? And that matters when you have blended families, right? Suppose the person who died had children from the first marriage. Who gets the money? Does the second wife get the money, or the children from the first marriage? And that's where people like Robin Williams, when he passed away, right? Lots of fighting. Right? Because there were children from the first marriage, the current wife wanted her money. It's a complete disaster.
Yes, everything has to be really written and discussed in advance to avoid any dispute.
Right. Anything that is uncertain can be litigated, and that's bad. And that's why we want to make things as clear as possible. And that is why those three-page trusts, when my clients come in and they say, can you update the trust for me? I said, well, how come you don't call your lawyer that prepared this trust? They said, that person doesn't answer my phone call. I'm not surprised, right? Anybody that prepares a three-page trust probably does not want to have a phone call again, because they cannot answer those questions. And so anybody, I have lots of examples that I, have from clients. Of course, I black out the names, but these are insufficient trusts. That is like driving the Yugo, that car that we had in the picture. It is a disaster waiting to happen. And so it's just, it's important to have everything in place. And so you don't wind up in this state, which is when it's too late.
Yes, totally agree. This is a question, hopefully, we've been holding up Michelle, so maybe you can answer this one as well. Does a married couple need a separate living trust?
Yes,
so it could be an easy or
it is an easy question.
Complicated.
It is simple. I have clients who are married and they still have separate property trusts. And the reason is because they have, not always, but sometimes the parents of one of the kids wants to give money to, like, a house to only their child. They don't want to give it to the son or daughter-in-law. And so they have a separate property trust. So their child, after they get married, has a trust, and it's called a separate property trust. And that only holds the money of the parent that gave the money. So it never gets commingled. So it is possible.
So separate living trust for each of the spouse, if that's what you mean, or like just separate living trust and separate property trust for one married couple?
So they can have separate. The problem is that if a person is married, they definitely going to have some joint assets, because under the law, there is going to be money that is growing as community property once they got married. So once a person decides to get married, there will be joint assets, whether they like it or not. The money that they're making after marriage is considered community property. And so there needs to be a trust that deals with what happens to the joint money. But in addition to the joint money, the husband and the wife can create different trusts for separate money. And that is usually because the parents of that child said, I don't want to give you money that's going to fall into the community property. So they don't want to commingle. Yes. So that then the married couple, let's just say the daughter, will have a married person trust and a separate property trust.
Yes. So like, say you mentioned about a case, if the single person have their own property prior to marriage, that they already created a living trust, and then this person get married, then it's likely they create another living trust that is community property.
Correct.
Yeah.
And that's the best way to do it, because We don't want to be
Yeah.
we don't want to be penny wise, pound foolish. We don't want to say, oh, I already have a trust. Let's mix everything together. Because down the road, when something goes wrong, then that divorce lawyer is going to be going after everything. Right? But if it was clear that there was a trust that was always separate property, it's untouchable because inherited money is always protected. But you just have to keep it separate in a separate silo, cannot be mixed with anything else. And that is how my trusts work, even for the outright distribution. Remember that basic plan? I still protect my clients as best I can. I tell in the trust that when the money goes outright to the kids, it must be deposited in a separate property account.
Yeah, that's very important.
And that's for the basic trust, that even that protection is built in there.
Good to know. Yeah. Well, that's very good. We learned a lot this morning. We really
it's a lot to think
all
about.
Your time and effort. Yeah. We definitely, in this country, we need a very good lawyer to work with, a good CPA, and possibly a good real estate broker as well. Yeah,
absolutely. You definitely need the real estate person. The real estate broker grows your money, and then the estate planning lawyer helps you make sure you pass the money onto the kids. But the person who grew the money was you, Monica.
Yeah, well, I could see that a lot of my clients have a lot of wealth accumulation throughout the years with the acquisition of properties. So having it protected for themselves to enjoy and also pass on to the next generation is very important.
Yes.
Thanks so much again, Michelle. I really appreciate everything that you've done for us, and it is very helpful. And I'm sure that a lot of my clients would be interested to get connected with you and learn more, and start doing their trust or update the trust.
Sounds good. And so if anybody has questions, or if you want to take advantage of that $500 discount, feel free to reach out to Monica, or you can have a copy of the slides, and my information, my contact name and email, phone number are all there. Set up an appointment, and I'm happy to give you the 30-minute free consultation.
Excellent. Thanks so much. Yeah. Thank you everyone for attending. Yeah, we'll be sending out the PDF of the presentation and the recording by early next week. Yeah. Thanks again, Michelle.
Thank you. Thank you, everybody. I hope you have a wonderful weekend.